What is long-term illness and injury leave? Long-term illness and injury leave is unpaid job-protected leave that is provided to employees where their work absence arises from long-term illness, injury, or quarantine, and the work absence is measured in weeks or months. Employment standards legislation can vary significantly as to the scope and duration of long-term illness and injury leave, if it is even provided, such that it is essential to look at the employment standards legislation of the jurisdiction that governs the employee's employment. For example, employees subject to the Alberta Employment Standards Code, after 90 days of employment, will look to Section 53.97 of the Alberta Employment Standards Code to discern the specifics of unpaid job-protected long-term illness and injury leave, not exceeding 16 weeks in a calendar year, due to illness, injury, or quarantine, that is supported by a medical certificate stating the estimated duration of leave and any changes thereto. By comparison, employees subject to the Canada Labour Code will look to Section 239 of the Canada Labour Code to discern the specifics of unpaid job-protected personal illness and injury leave not exceeding 27 weeks, with up to 10 initial days of paid leave, due to illness, injury, or quarantine that involves the provision of prior written notice or as soon as possible if not provided in advance, together with the expected duration, in addition to subsequently providing a medical certificate issued by a healthcare practitioner indicating the employee's inability to work for the period of their absence. The Manitoba Employment Standards Code provides up to 17 weeks of unpaid job-protected leave for serious illness or injury that is set out at Section 59.10 of the Manitoba Employment Standards Code. The Saskatchewan Employment Standards Act provides up to 12 weeks of unpaid job-protected leave for serious illness or injury, increased to 26 weeks if the employee is receiving workers' compensation, that is set out in Section 2-40 of the Saskatchewan Employment Standards Act. Certain provinces, such as Ontario and British Columbia, have only legislated short-term illness and injury leave, known as sick leave, being limited to 3 days or 8 days respectively in their employment standards legislation, such that those employees must look to their employment contract for job protection arrangements when they take time off due to long-term illness or injury. An employee's employment contract, including a collective agreement, can provide a greater right or benefit than the long-term illness or injury leave standard set out in the applicable employment standards legislation, such that the superior terms of the employment contract would prevail over those of the legislation. If the employment contract does not provide a greater right or benefit, then the long-term illness or injury leave provided by the applicable employment standards legislation controls. Additional statutory rules may apply depending upon the particular employment standards legislation, including restrictions on the termination of an employee's employment and related prohibitions, continuance of benefits and contributions, job transfer protections, notice to return to work requirements, suspension of operations impact, and conflicts with employee vacation time. The Canada Labour Code also provides heightened rights and protections with respect to work-related illness and injury that are set out in Section 239.1 of the Canada Labour Code. Thank you.